Buongiorno, benvenuti. Thank you so much for joining us for a presentation on what to do if you inherit property in Italy. At the end of the presentation, Antonello will take some questions from the audience. So please use the Q&A function at the bottom of your screen to submit a written question. We are recording this webinar, and so we'll send the recording along with Antonello's PowerPoint within the next 2 business days. And now I'd like to welcome NIAF board member Joe Gulino to kick us off. Joe.
Thank you, Gabriella. Good afternoon. I'm honored to present to you What to Do If You Inherit Property in Italy, a virtual event brought to you by the National Italian American Foundation. NIAF is a membership-based, nonpartisan, and nonprofit organization. Founded in 1975, NIAF's mission is to preserve the Italian American heritage and culture, promote and inspire a positive image and legacy of Italian Americans, and strengthen and empower ties between the United States and Italy. NIAF is based in Washington, D.C., and we're very excited to host virtual events to share information and engage with Italian Americans from all over like never before. All our past and future webinars can be found on our website, niaf.org. And if you're not a member of NIAF, we encourage you to join us and to support our mission. And with that, I would like to introduce property buying expert and attorney, Antonello Pierro, founder of Pierro Associates, who will be presenting tonight's webinar. Pierro Associates is an international law firm, an international Italian law firm with offices here in Rome, Milan, and with specialists in Los Angeles, California. They have expertise in a wide variety of practice areas and provide clients with comprehensive and integrated legal advice and representation, both to individuals and to companies that seek to invest in Italy. Antonello is an Italian practicing attorney with over 2 decades of experience. He was admitted to the Italian bar in 1999 and the California State Bar in 2019 as a foreign legal consultant. He represents American clients, both individuals and companies who acquire businesses and real estate here in Italy. He holds many memberships in American legal associations, including the California Lawyers Association, the National Italian American Bar Association, and the Italian American Chamber of Commerce West. I'm pleased to be here in person this evening with Antonello Pierro. Buonasera, Antonello, and welcome.
Hello. Thank you, Joe, for the introduction. Hello, everybody. I'm Antonello Pierro, and today we are going to talk about this very, I would say, very hot topic, what to do if you inherit property in Italy. Let's start with a brief introduction about how to get a property in Italy in case you will inherit any property or any asset. Basically, there are 2 ways to inherit property in Italy. This will be according to a will, or if a will doesn't exist, the Italian regulation, and in particular the Italian civil code rules, will entitle some specific people, some specific person to be the beneficiary of the transfer of the property. I think it's important to just to give very brief outlines about the Italian civil code regulation. So the Italian civil code provides that if there is not a will, the inheritance goes to the spouse and children. This because the Italian regulation, Italian law is very protective in regards of the family. And so in case there are no spouse or children, the inheritance goes to the relative, some relatives listed in the Article 565 of the Civil Code. These rules list the category of the relative who can benefit in case no spouse and no children are there when the stator or the person who died. So the event of the die happens.
And the code, as we see on the slide, you mentioned that there's a certain percentage that has to go to the spouse if there are no children, or to the spouse and to the children. Can you explain how that works or what those percentages are like?
Right, yes. So because as I said before, the Italian regulation protects the right of the family members to get a part of the asset of the family, part of the property. The rules provides that the testator should leave at least, should allocate at least 50% of the asset to the spouse, and if there are to the spouse if there are no children, and in case there are, spouse and children should go 1/3 to the spouse and 1/3 to the children. So, and this reflects the philosophy of the Italian law regarding the idea of the family. This is a long tradition, historical tradition in Roman law, ancient Roman law.
And so if the testator has has only a living wife or a child, can he make a will that sends 100% of the property to somebody else other than the wife or the spouse and the children, to a friend, for example? How would that work according to the code? Is that even possible?
So this is a very good question, because sometimes people who is not aware about the regulation, and this can happen sometimes, and if you make a will and you will leave 100% of the asset, even if there is a spouse or there is one child or children, these allow the legal beneficiary, so I mean children or spouse or both, to sue the people who benefit by the will, to ask to the judge a judgment who reduce the asset to the 50%. In other words, the judge will rebuild the asset in favor of the legal beneficiaries, children, spouse, or both. And but the interesting thing is that if the testator will leave 100% of the asset to the further person, then wife and children, or spouse and children, the will still be valid, wouldn't be void, and will be the burden of the legal beneficiary to sue
the friend in this example.
Right?
Yeah. Okay. So I could leave a property to a friend, but if I have a wife and children involved as well, I cannot leave 100% of the property to that friend. And if I try to leave more than the law allows, the court will revise the will, or will fix it to make sure that the proper share goes to the spouse and to the children.
Yeah, that's right.
Okay, so maybe we can move on to the next slide, to the next step, and talk a little bit more in detail about the process to follow in case a person inherits a property located in Italy. You can take us through some of those steps, and then we'll also look at what happens if there's no will.
Sure. So then, let's say that we have the news that we inherit a property in Italy. We are in another country and we don't know how to handle this process. And we have to take in mind that the first step to start this process happens with the death of the person. The legal succession process starts with the death of the person, and but this wouldn't be automatically. So after the death of the person, it will need an official public declaration that named in Italy atto notorio, which we will call a public declaration here. So the public declaration should be made by any person who has an interest, and he or she can appear before an Italian notaio. I just remind for those who didn't participate to the previous webinars, notaio in Italy has a similar function of an attorney, but he's also a public officer, and he play a very different role from the U.S. notary public, and he has he's very legal competent, and he has very legal knowledge, and the Italian law requires that to make this public declaration, the person should appear and should make the declaration in front of the notario, he should communicate, he should declare who is the beneficiary if he knows of the will of the inheritance.
So in any process, which you say starts with the death of the person, the next step will be involving the notary and having him or her review the declaration of death and any will that may have existed. But the first step will be for someone to get in contact with a notary to start that process. Is that correct?
Right. Yes, and this, as I said, this process can be made. This declaration can be made by anyone who has an interest, or also even if he doesn't have interest, but he can start the process with the declaration. And but let's learn a little bit more in detail. What is the content of this public declaration?
Right. And on the next slide, we can see the two different stages. So one, if there is a will that you can walk us through, and one if there's no will.
Yeah. There is, In depending if there is a will or if there is no will, there are two little more different details which must be declared. Let's talk about the option. There is the will. In this case, the person who appeared before notario should declare that there is an existing will, and in case he has, because maybe the beneficiary sent to even if the beneficiary is abroad, can send to the person who appeared in front of the public notary, can send the copy. He can provide this to the notario, and in addition, he has to declare who is the beneficiary, and he has to provide all the related details, including name, last name, date and place of birth and place of residence. And the other option, if there is not a will, is more simple, because the person who appears before notario, he just needs to declare that there is a beneficiary according to the general rules of the Italian Civil Code, which we talked before, which we referred before. And in both cases, it will need to provide to the notario. This is very important requirement, and is the death certificate of the person died. I know that for those who living abroad, in our case, living in the United States, the death certificate will be in English. So in this case, the death certificate needs to be translated in Italian language. Need to add a declaration made by the certified translator, and finally get apostille, which will allow the certificate to be recognized in the Italian legal system. And just very practical point. So the public declaration can be made by a relative of the person died, but can be made also by an attorney who doesn't need, for this specific case, to get the power of attorney. He just appeared and he declared that he has a knowledge about the event of the death of the person, and he can make the process working.
And the beneficiary needs to get into contact with a notario in the district or in the region where the property was located, or can they use any notario, any notary that they have contact with elsewhere in Italy?
Oh, thanks for this very, very important question. So before when all the database of the Italian real estate register was more in paper than digitally, was necessary to appeal in front the notaio in the district where the property was located. And now that all the archives, the real estate archives and database are digital, you can appeal wherever you like, because all the notaio can access to the database and register all the proper papers in the public register by digital data.
Okay, so we can move on here to the slide you see now and talk about the succession process. Just a reminder to everyone who's participating, if you have questions, to put them in the Q&A box, as Gabriella explained. And Antonello, I'm not sure if you can see, but there are already a lot of questions coming in. So I think we have some interested participants who will ask some questions as we go on later. But if you can talk about the options that the beneficiary has now that the succession process has started.
Yeah. So we can introduce now the most interesting topic points, because let's say that you're living in the States, you get the notice that you are beneficiary of a property because there is a will, existing will, or because just the person died, didn't have any other relative, and you are the beneficiary according to the Italian law. This doesn't mean that you have necessarily accept the inherit, because the Italian law provides three separate options according which the beneficiary can act in order to decide to accept or do not accept the assets of the property located in Italy. So of course the most simple option and the more straight option is to accept the property. In this case, the beneficiary will make the acceptance declaration of the asset of the property. If he has some doubts or some concern, he can accept the property with the right of inventory, or he can even decide to not accept. In this case, he will make the declaration to renounce the inheritance. Let's talk a little bit in brief, very brief, or how it works and which are the consequences of those three options we mentioned. So, of course, in case of the beneficiary decide to accept the inheritance, he or she will need to appear before the notaio and declare that he or she intends to accept the inheritance. And it's very important because after this declaration, the notaio will notarize this declaration, and this will entitle the beneficiary to transfer the property under his name. It's important to know that the beneficiary has to make this declaration within 10 years from the death of the deceased. So there is a quite considerable long time to make this declaration. So shouldn't be made immediately or after so short time the death happens. And also, just for those who are not in Italy or cannot travel in Italy, just to be aware, it's important to be aware that the declaration of acceptance can be done also by an attorney. In this case, the beneficiary has to give the power of attorney to the lawyer, to the attorney that he will choose.
And that power of attorney could be done, for example, for someone who's watching from the United States, could do that power of attorney through the Italian consulate in the US, and then, for example, grant you the power of attorney to handle the declaration of acceptance?
Oh, no, not exactly, because recently the law has changed, and the Italian consulate make the notarized power of attorney only for those who have Italian citizenship. So for those who are just not Italian American, but just American, they can appoint an attorney by the the regular power of attorney made before the U.S. public notary, and then once they appoint an attorney, they should get apostille over the U.S. power of attorney, and in this way the power of attorney will work in Italy, and then so this is quite easy process, because so based on my experience in all the states in America, it's quite easy to get the apostille. So it's something that you can get in 3-4 working days, and wouldn't affect the process because it's simple.
And it sounds like a complicated thing, and most people probably haven't heard of the apostille unless they've been involved in some international transaction before, but it's actually a very simple document or certification, let's say, that can come from the Department of State in your particular state. So I'm based in Florida. I can send the documents to the Department of State in Tallahassee, and a few days later, as Antonello says, I will get this document certified, attesting that it is an actual copy of a death certificate or an actual notarized version of some other document, and then it is accepted in Italy as if it were a public document in Italy. Not just in Italy, this applies in most countries around the world as well. So it's a little bit of a formality that might take a few days, but is nothing complicated that can't be done.
Yeah, absolutely. So let's see the option B. So the declaration of acceptance with the right of inventory. This is a little bit more complicated option, because when the beneficiary is not aware about the financial situation of the deceased, and it might be some critical issues regarding the inheritance, for instance, debts or litigation connected to the property. The Italian law provides the option to accept the inheritance and to make a due diligence to discover if there are pending debts about the property or further tax issues or other disputes around the property. The very important point that the legal consequence of this declaration would be that the beneficiary will not be liable for his personal asset, for the debts or of the deceased. So this will, so in other words, it will allow the beneficiary to protect his asset in case his property will join the property of the state or of the property came from the inheritance. And finally, then there is the option that the beneficiary intends to renounce the inheritance because for many factors, for many reasons. Sometimes there are all the properties in Italy that can be left can be transferred by a will or by succession, and then the beneficiary can learn that it will be more expensive, for instance, to remodel or to rebuild than the value of the same property. In this case, probably doesn't worth to gather the inheritance and do not accept and do not get it because it would be very expensive.
Right. I probably had the same question as many people. Why would I ever renounce inheritance of a property on the coast in Italy or a vineyard? What would be the reason to do that? But you explained it sometimes could be more complicated or expensive than it seems to inherit a property.
Yeah, right, absolutely. So, and let's then let's talk about the conclusion of the succession process, which will be the
taxes. We're going to talk about the taxes, right?
Taxes.
The taxation, exactly.
Yeah, probably. This is part of the final deed. Yeah. So we have the final part of this process, what we call deed of succession, which will be a report signed by the beneficiary, which will contains all the details regarding the inheritance. Let's say that the beneficiary will get an apartment in Florence. So this report will have all the information, all the details of this property, and which will allow to identify exactly the property. This report has to be filed into Italian IRS called Agenzia delle Entrate, and it has the function also to assess the value of the inheritance and the amount of taxes you have to pay. I'm sure this will be a very hot topic for the question, and it usually is, but probably we can talk later, because I guess it will be some question. And this report is usually prepared by notaio, by an accountant, or can be made also by an attorney. Doesn't need to be made necessarily by an Italian notaio. And so
that brings us to the end of the process. Now you're the owner of the property. It's been transferred to you.
Yeah, notaio, yes, right. Notaio, with this report, with this document signed, will file this declaration and the deed of succession in the Italian IRS, and finally into the real estate public register, which will allow the beneficiary to become the owner of the property. And this is in brief all the process, which of course can be affected by many bureaucratic issues, especially when the beneficiary is living abroad and there is a documentation which will need to be translated in English, and need apostille and need notarized signature. But in brief, it works like that, and probably is much more simple than it shows talking by the legal details.
Okay, so I know the participants keep sending their questions along. I have one which might lead us into the next topic, into the last slides of your presentation. If I had a property in Italy, why should I even think about a will, or should I think about a will? What are the benefits of having a will? Why should I do it?
Yeah, yes, good question, because yes, talking about the will, I'm aware that most of all, especially in the United States, have set up a trust, or they have made much time in advance the American will. And the question is, why to make an Italian will if I own a property in Italy, like many, I'm sure many Italian American and many Americans and many of those who are participating today at the webinar own property in Italy. Why should I make an Italian will? So first of all, let's say that for the American citizens, it's possible to make an Italian will. For those who didn't know about that, when the property is located in Italy. And but the further good news is that the American citizens shouldn't necessarily apply the will the Italian law. So they have more flexibility in order how and to whom to transfer the property, and more in general all the assets. Because as we said previously, if a foreign citizen would make an Italian will, and if it would apply just the Italian law, this will be it will bring a lot of restrictions in terms of the person beneficiary, because as we said, we should at least allocate 50% of the asset to the spouses or the children. So in this case, Americans can set up a will and decide how to transfer the property and to whom to transfer the property with much more flexibility, because they can apply the Italian law. I think this is a very important point. But to answer to the question made by Joseph, I think there are some specific and legal technical reasons about why to make an Italian will. First of all, let's say that if for those who own property in Italy, if they would include the Italian properties in American will or American trust, in case you like the beneficiary would like to transfer the property in the future, it will be necessary to show to the Italian IRS the fully document in English, which will need to be translated with apostille, and this will open many issues relating the taxes. I mean that it would be possible that the Italian IRS would like to learn more about all the assets located not just in Italy but even in the States or even in other countries, and it might be there are some critical issues in order the tax charges. And it's worth noting that in the last 10 years, the Italian IRS became very aggressive about the asset located outside of Italy. Doesn't matter if you are Italian, American, America, or I don't know, you British. So they want to learn about where are these assets, if you pay taxes there, and how much taxes did you pay, and if you are probably eligible to pay taxes also in Italy. So the suggest is to keep completely separate the Italian will by the American will, just in order to avoid any tax charge in the future when you are going to transfer the Italian property, because we are going to show the American will, and they will probably want to learn more about all the asset situation abroad. And so that is the main answer to the question you made about. And so it's a tax critical issues.
So first, it's important for someone preparing a will in the US to make sure it excludes any reference to any assets in Italy from that US will or US trust. That's the first step, I think you were suggesting, right?
Right, right.
And that way the US will or trust would only address property in the United States. I probably should have addressed this at the beginning. While I am a lawyer, I'm not giving legal advice tonight in Florida, in Washington, D.C., Pennsylvania, or any other state. And this certainly is not an area that is my specialty, but it's important to discuss how you might want to involve a U.S. lawyer or get a consultation from a U.S. lawyer who understands wills and trusts to make sure that your U.S. will and or trust is drafted properly to exclude a reference to any property in Italy. And I guess if I were to then want to make a will in Italy only to address the Italian property, would you also, Antonello, suggest that will in Italy exclude any reference to property outside of Italy, so that property in the United States or elsewhere isn't addressed by the Italian courts, or more importantly, by the IRS, the Agenzia delle Entrate?
Right, correct. And I would add, Joe, a further point that another reason to exclude the Italian property from American will or trust, especially regarding the trust, it's important to know that in Italy we don't have the trust. It's a typical Anglo-Saxon type of contract. Is a common law contract, and in Italy, in the Italian legal system is based on the Roman law, on the civil law. So we can recognize the foreign trust, and we, in the last 15 years, the case law recognized the trust, but it's very complex legal institute for the Italian courts, and the people usually doesn't know how it works, and even the judges in Italy are not very confident, they don't really know how to work with this. And so to avoid further complications, especially if you made a trust and not the will, it's very important to discuss with the consul, with the U.S. consul who take care about the trust and the will in the United States, and to talk about that, and probably to assess and to considering this topic, this option to exclude the Italian property from the American trust.
So we have a lot of questions that have come in. I know Gabriella and Andrea have been going through them. Maybe as they come back to join us and share some of those questions. A few questions that I've seen coming through quite a lot have dealt with how you find the owner of a property in Italy. You mentioned about the property records now being computerized, but it's still not really possible to search for the ownership of a property. So if I learn that Antonello has left me property in his will when he passes away, how do I find out that that property was actually owned by Antonello? Is it possible to search that, to carry out that check?
So if the question is that how to search a property based on the name, so if you have a name, last name, and date of birth, of course, yes, it will be possible to search a property in the public register, but at least it will be useful to know the region or the location, because there are many databases in Italy for each counties. So we have we have 20 region and 21 region, and the regions has some further counties inside of each region. So to make the research easier, it would be better to have at least the region where you assume the property was located.
Because we heard, and Gabriella and I hosted a session a few months back about the famous €1 properties for sale in Italy, and some of the difficulty with finding who the owners are, and that could be a regional issue as well, where the records are less accurate, certainly with older properties that haven't been transferred recently.
Yeah, probably that kind of properties, probably even the municipality, that they didn't know who is really the owner of the property, but that property are abandoned properties which for several years, probably 50 years, was not anymore used for anyone. But from the cadastral details, it's still possible to find out the origin, the previous owner would be okay, would be fine.
Okay, great. Thank you, Antonello. Another question that came in through many different times was regarding the 10-year deadline. If you...
So we're just...
Oh, sorry, Gabriella, I didn't hear.
Oh, can you hear me?
Okay, now yes, sorry.
That's okay. That's okay. So I wanted to ask, or many people have asked about the 10-year deadline. If you're a spouse or a child and miss that 10-year deadline, does that mean that you cannot inherit the property?
Oh, this is a legal deadline that should be respected, and the point is that if nobody will claim this property after 10 years, will be still possible, but the process will be more complicated, and wouldn't be enough to go to appear in front of the notaio to make the declaration, and you should claim this to the court through court proceeding.
Okay, great. And if a beneficiary, renounces the property, where does that property go? Does it go to the comune? The city owns it then? What happens?
The question is if there is no beneficiary, right?
Correct. If they renounce the inheritance.
The property goes to the Italian state.
Okay. And it ends up being a €1 home? Is that what happens? They end up selling it for €1?
Maybe, and then
Part
the
of
beneficiary,
those, probably, yeah.
and the beneficiary buys it back for €1. No,
Yeah.
I don't think so.
So getting back to the notaio, how would one from in America find a notaio in Italy and start that whole process?
How they would find notaio?
Yes, correct.
Oh, so there are in Italy, since they are public officers, so there are not many notarios, many professionals in all the district. And so if you don't know, and if you don't have an attorney or you don't have a relative here in Italy, you can go online and you can find the notaio in the area where the property is located. This is the best advice I can give. Just go online, find a notaio in the area, and contact notaio. But be aware that notaio in 90% of the cases, except the Milano area, they don't speak English. Most of all, they don't speak English. So will be some problem for those who doesn't speak Italian to communicate by phone and by email with them.
Yeah, and I think it's also important if you're dealing with a property transfer like that, you're dealing with a notary who may not speak English, that you also have, whether it's a lawyer like Antonello who speaks English or your own translator with you, to make sure you're understanding the complicated legal document that is being signed. And I'm sure with NIAF and our connections, there's also a way to identify those English-speaking notaries that we may know or that may have contacts with us at NIAF.
Absolutely.
Yeah.
I have a question from Arturo Shivers. It's regarding trust, going back to the trust. With the new special tax/residency program for foreign investment in Italy, it seems that there will be more and more case precedents for foreign business owners who pass away and have Italian assets, like businesses and real estate, as well as foreign assets. Do you have a recommendation for a specific area of practice attorney to refer to in that case?
I would recommend to talk with an tax accountant more than attorney for these specific issues. There are many tax accountants who handle this type of matters, and they can address the investors and all the taxation consultation, taxation advice.
Great. So Antonello, what if one does inherit land from your parent, that passed away many years ago, but don't know where the actual land is located? How can one go about in finding where that land is? It contacting the local city hall? How does one go about finding out where the land is located?
So we assuming that we know the name and last name of the
yeah, for example, like it's my parents.
Yeah. No, this is still possible to find the location to find the property based on the two main database we have in Italy. One is the Italian real estate public register, where are registered all the titles, and the other one is the kind of, I think in English is cadastral register. I don't know if it makes sense. Cadastral.
Yeah, we could also say just the property registry, to explain that it would be the record of all of the ownership of properties and who the owners are. So in some states or counties, it might even be the local tax office or the recorder of deeds office, depending on what it's called in your state, that would show then who has owned the property.
And so based on those these two to register, is possible to find the land, to find the parcels, to find the location, and how much big is the land. So, and this can be made by a notario, by an attorney, by an architect. There are many professionals who can help to find out the location, to identify the property, whatever it is, land, house, apartment, or building. So,
okay, great. And if a property is owned by multiple people and one of those persons dies but has spouse and children, do the other living property owners have to do anything with the inheritance process?
So I guess if there are two maybe unrelated individuals who are owning a property. So if Antonello and I own a property together and Antonello dies, what happens to his share? Does it come to me or does it go to his wife or children or heirs? How does that work in that case?
So if I own a share, just a piece of property, so let's say a share of the property, and if I have a spouse or children, it would apply the same principle we discussed in the beginning of the webinar. It will be 50% to them. We call legitimate beneficiary, and 50% if I made a will to the other beneficiary. So that is how it works. So it would apply still the same rules we discussed in the beginning of the webinar.
Does it get complicated though very quickly, where you could have multiple owners with different percentages of ownership of the property? It's getting divided. My 50% stays with me, your 50% gets divided then into another 50% or another third and a third. Is that common that you have multiple owners of different shares of the property?
Yeah, I would say that this is a very typical situation, especially in the south of Italy, where people inherit the house of the grandfather or grandparents, great-grandparents. And I have to say that it's very common for the Italian Americans living in US, who very often they call me and they inherit a piece of property, I don't know, 1/3 or 20% or 25%, because the grandfather left one piece to one children, one other piece to another children, and there are the grandchildren living there, because no one of the children was living there, because one went in America, one went from the south of Italy, emigrated to Milano or to Roma, and so theoretically and legally the property is owned by the 3 or 4 legal different owners, but is still living there the grandchildren of the great grandfather or grandmother was the original owner. So I mean, in south of Italy, it's very, very common situation. And in the last 5 years, I had a few cases where I was called by someone from States who got 25% or 10% of the property in Abruzzo, in Sicilia, or in Campania, and they still own this property, but they never went to see it because the grandchildren still living there. So,
yeah, very complicated. Antonello, if someone grants a power of attorney to a friend or relative in Italy, how can that power then be revoked?
Can be revoked. Oh, in this case, he will need to make a further deed before in case it was made before the notario, the U.S. public notary. She or he should go back to the U.S. public notary, notarize the declaration of revoke, and then again apostille, and notify this deed to the attorney appointed previously by the person. Yeah.
Perfect.
Yeah, or if they did in Italy, should go to the same Italian notaio to revoke the power of attorney.
Wonderful. Well, that is, oh wait, we have one more question from Mary Ann, who says, what type of fees do an Italian notaio charge a U.S. citizen to hire them for this process? Just an estimate, più o meno.
So it depends of the value of the asset, because the fee of the notaio are also based in percentage on over the value, entire value of the asset. But let's say that it could be starting from 1,500 till 3,000 euro for the entire process. But plus the beneficiary should pay the taxes according to the specific asset and the specific value, which is not possible to make an estimation. And but if I'm sure we will get some further question later, but I can anticipate the topic that for those who inherit the property, for those like spouse and children, the Italian government recently changed the legislation during the past 10 years, and for the property which value is less than 1 million euro, it wouldn't be charged any tax for the transfer.
Okay.
So the good news that for all the property up to 1 million, the beneficiary shouldn't pay any taxes if the beneficiary is the spouse or children.
Okay, perfect, great. Well, go ahead, Joe. Do you have another?
I was going to ask if we had time for further questions.
Yeah, do you have a question?
No, I just saw this most recent one that came in, which I think is interesting. Someone saying they want to leave the property according to an American will that is 100% to the surviving spouse, the children getting it only after both parents die, which I think would be a very common approach in the US. How could I do that, she asks, and can I just use an American will? So can I use an American will to have the property pass as it would in the US, which is different from what Antonello has explained to us about how it works in Italy?
So, Joe, I'm not sure I get the question. I understand clearly the question. So, if the question is if the American citizen can use the American will to pass the Italian property, so the property located in Italy, to someone, including his wife or children.
Exactly. The example she gives is 100% to the spouse. So if she leaves it 100% to her husband in her American will, how does that work? Or does that work?
Yeah. Theoretically, this is possible. It works, and so the American will need to be recognized in the Italian legal system. So need to be translated in Italian by a certified translator. Need to again get apostille. It needs to get apostille, and then we need to make it become public the will in Italy, file before the Italian public notary, to file the Italian public register, and finally to get to transfer the property. Yes, it's possible, but the process will be much more complicated, as we discussed before, especially if in this will be included further properties not located in Italy.
So I think topics for future webinars are how to draft your will in Italy, how to have Antonello help you prepare your will in Italy. But there have been a lot of questions, and the topic is, I think, too complicated to get into in this session about inheritance tax and how an American citizen might have to handle the inheritance tax issues, especially if they're not living in Italy. And that may be a topic for our next session as well.
Yes, I'm writing it down.
So in brief, we can just answer that the taxation for the transfer doesn't matter based on the legal succession of an existing will be for all the people except their spouses and children, will be some specific percentage calculated on the value of the cadastral value of the property. Cadastral value is a much less expensive, is a smaller value than the real value of the property. So the tax will never be expensive if we just talking about the properties, not other kind of assets like financial investment or liquidity in the banking account, and will be the same taxes charged to the Italian citizens. So wouldn't be different between foreign people and Italian citizens. So in brief, just to answer in brief, and of course we can discuss later in a further webinar, in a further section, if it will happen.
Okay.
Great.
That's
Well,
great.
thank you, Antonello, and thank you, Joe, so much for your time today. As I mentioned earlier, this webinar has been recorded. We're going to send all of the recording as well as Antonello's PowerPoint slides to all of our registered attendees, so you can refer to them and review them at a later date. I'll also share Antonello's contact information, so you can contact Antonello directly for any of your needs in Italy. I'll let Joe close it out.
Great. Thank you, Gabriella. Thank you all for supporting NIAF and another webinar in our series. As the year will draw to a close soon, please stay tuned for updates about future webinars and in-person events. On behalf of the entire board of directors of NIAF, I'd like to thank you again, Antonello, for your participation this evening, and to thank all of the viewers today. Buona serata a tutti.
And thank you very much for NIAF to host me here. Thank you, Gabriella. Thank you, Joe, to organize this amazing event. Very interesting event. I hope it was useful to get this information, and I'm looking forward to seeing you soon in the next section, next webinar in the future.
Great. Thank you, and happy Thanksgiving.
Ciao. Bye.
Ciao.
Ciao. Ciao. Ciao.